Welcome everyone, this is Amer from U-Council. Today we'll talk about workplace bullying and harassment in Ontario. And if you have any understanding of what's going on in workplaces, you would notice that workplace harassment and bullying is on the rise. And there are many reasons for this, but some of the reasons are, one, we're spending increasingly more time at workplaces, even more time than what we spend with our families and friends. And just by virtue of spending more time, it is bound to happen that there will be frictions between employees and co-workers, and that gives rise to all kinds of issues, including bullying and harassment. Secondly, the workplaces are getting more stressful. There's more demands from the employers, and the nature of economy is changing, which is adding another layer of stress on employees. And finally, in workplaces, employees are often put in competition with each other, and that naturally gives rise to friction and all kinds of issues which can emerge in the form of bullying and harassment. So today's course is about workplace bullying and harassment, and the fundamental things that we'll discuss is explain what workplace bullying and harassment actually means, so that you can understand, you can apply it in your circumstances and know whether you are experiencing workplace bullying and harassment within its legal definition in Ontario. And secondly, we'll provide some basic steps that you want to undertake in order to prevent workplace bullying and harassment against you, or if you are experiencing bullying and harassment, then what kind of remedies you can get through that process. So let's get right into it. Our usual disclaimer comes first, that this course is not legal advice, so if you have any specific questions, you must contact a lawyer or paralegal. So let's talk about workplace harassment. The first question that should come to your mind is, what you are experiencing, is that workplace harassment or bullying or not? So let's get to Google, and then you want to type in legislation called Occupational Health and Safety Act. It's available on Canly. Click on that. This is an Ontario legislation that deals with all kinds of health and safety matters, including workplace bullying and harassment. So this is the act. You can review it at your own leisure. But let's get into workplace harassment and see if we can find a definition. Here we have. So this is in section 1. It's called the definition section, and workplace harassment is defined here. And I want to go through this slowly with you because we're talking about definition, and I want you to really clearly understand it. So workplace harassment means engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. So if you carefully read this over and over again, you will get the theme out of this specific definition, that the definition of workplace harassment is very, very broad. It's extremely broad. And there's good reason to keep it so broad, because the kind of circumstances that can be defined, can be explained as harassment are so various, are so significant, so diverse that a narrow definition would be too restrictive, would not cover all of the scenarios. So for instance, if the legislators have put in here sarcasm, bad jokes, inappropriate language is harassment, then that would have been too narrow. So remember that it says vexatious comments or conduct. So the comment or conduct has to be vexatious, and vexatious is a very broad word with so many different interpretations. So that conduct has to happen against a worker in a workplace, and then that is known or ought reasonably to be known to be unwelcome. So either the person who is bullying or harassing the other person, either the person knows, or reasonably to be known, meaning that objectively, when people look at that situation and they look at that conduct, they will come to the conclusion that yes, this was a vexatious comment or conduct, and it would come under the definition of workplace harassment. So what is the key message here is that workplace harassment, by definition in law, is a very, very, very broad definition, and it can cover a variety of circumstances. So that's something to keep in mind. If you scroll down, I want to show you two other things. Workplace sexual harassment, it has a separate definition, separate meaning, and you can review it. And then workplace violence is a separate category, and it has a separate definition. We're not covering all of those today. We're focusing on workplace harassment. So what you want to remember is that there is a legislation in Ontario that deals with workplace harassment. It's called Occupational Health and Safety Act. We just looked at that. And the definition of workplace harassment is in section 1 sub 1. You also may have noticed that there was no word bullying in that Occupational Health and Safety Act, and primarily because the definition of harassment is so broad that it will include bullying anyways, and so bullying is not separately defined. But workplace harassment, as it's defined in Occupational Health and Safety Act, does include all kinds of bullying. So let's go through some examples, and these are very, very few examples. There are so many circumstances where, because of that definition, you can find the conduct to be vexatious enough and to fall under the category of workplace harassment. But let's look at some of the examples. Insulting language, inappropriate language, name calling, swearing. These are sort of some of the obvious, simple examples of workplace harassment. Jokes, embarrassing jokes, hurtful jokes, humiliating jokes about a coworker, either in his or her presence or not, could constitute workplace harassment. Gestures, body language, and this happens quite often, and we get a lot of complaints where the conduct, the person who is bullying or harassing is not actually saying anything verbally, but his or her gestures and body language is so inappropriate that it can amount to workplace harassment. So I'll give you an example. I mean, this was from one of our cases that we dealt with, where this particular employee, they would sit in an open office environment, and the supervisor or the manager will come in and she will say good morning or hello to each one of them while specifically ignoring this person. And this happened on a daily basis. And so if you experience that kind of behavior every morning, every day of the week when you come to work, you can imagine what kind of cumulative impact this will have on that person. So that kind of behavior would constitute harassing behavior. Similarly, physical touching, any inappropriate physical touching which is unwelcome can amount to workplace harassment and can amount to sexual harassment as well. So you want to look at both definitions. Another important thing that you want to notice is interference in work, and I want you to sort of understand this a bit more. Interference in work, there are the two kinds of interference that a manager or supervisor can have in your work. One is sort of a constructive interference. You're doing something wrong, or you need some coaching, or you need to be monitored in certain times, and that may be appropriate. But sometimes the manager or the supervisor is so micromanaging your work or so involved in your work in a way that it almost becomes harassing, and it's ongoing, it's constant, it happens all the time, and that may amount to harassment too. Other examples could be one is sort of micromanaging, getting too involved, and the another example could be taking away work from you. So if, for instance, there was one case we dealt with where the employee who was a managerial employee whose attendance was required in certain meetings, but she was completely ignored. She was not sent meeting invitations. She was ignored from the meetings and where the key decisions were made and whatnot. And that could be a form of harassment too. So those are some of the examples of harassment. But at the same time, you want to keep in mind that constructive criticism of your work. If you have done something wrong and you are appropriately reprimanded for that, that is not harassment. That is sort of the management of that work and the management of the employee. So sometimes the line is a bit bleak, but you want to, when you look at all of the circumstances of what's happening, I don't think that it is for a decision maker, for a judge, for an arbitrator, it will be a very hard thing to sort of figure out whether it was harassment or whether it was simply a management style of the supervisor or manager. Okay, so let's jump into how do you fight workplace harassment? If you're experiencing workplace harassment, what do you do? I'm going to talk about, I believe, 4 sort of concrete steps that you want to take if you're experiencing workplace harassment. And step number 1 is always, if you're experiencing workplace harassment, you must seek help. For yourself, for your physical, for your mental health, you must seek help. And if you are concerned about your physical safety to the extent that you need to call the police, you must take that step. But in terms of help, if you need to go see your family doctor, your therapist, your psychologist, your psychiatrist, you must do that. There are 2 advantages of doing that. Number 1, you're getting treatment. You want to feel better. You want to look after your physical and mental health. Second is that when you go see your doctor and therapist, you're reporting these incidents and they are getting documented with that specialist, with that therapist. And further down the line, if you are before an arbitrator or a judge in a court or an investigation, those documents, those doctor's records, those medical records become part of your evidence, and they may support your case. So if you're experiencing workplace harassment, I think it's important to get that documented with your doctor and therapist if you need to seek help. So do not feel shy, do not feel reluctant in going and seeking help. One more thing you want to explore is, and many at least large employers in Ontario and Canada have what's called EAP, Employee Assistance Programs, which are helplines, confidential, third-party help, where you can call, usually 1-800 number, and if you're experiencing psychological, physical, mental harassment, workplace harassment, and bullying, you can contact them. They have therapists available. You can share the information confidentially. You can get help, and if that's something that's available at your workplace, you must benefit from it. Must take advantage of that. Step number 2: document, document, document. I cannot emphasize this point enough. Why? Because in majority of the cases, workplace bullying and harassment is verbal, it's oral. There are no emails, there are no memos, there are no letters that contain harassing, bullying language. Sometimes they do, but in majority of the cases, it's all oral, verbal. And so if anyone, either an investigator or a judge, is reviewing this matter, it all comes down to he said, she said. And so you want to make sure that you document whatever you were experiencing contemporaneously, meaning that if it happened to you today, you want to go home and document it in detail so that you have that record that you can bring to your investigation, that you can bring to your trial and provide it to the decision maker. The advantage is, number one, you now have documented something which was done contemporaneously, so there's some evidence of that. Number two, when you document something on an ongoing basis, it will have more details in it. Whereas if you try to document it, 6 months down the line, you may not remember the parties who were present. You may not remember exactly what was said. You may not remember, what time it was said, what was the circumstances of that, comment and whatnot. So documenting on an ongoing basis, if you believe that you're experiencing workplace harassment and bullying, is essential. So you must do that to protect yourself. Some of the things that you want to keep in mind is what, when, where, who. So what happened? What was the issue? What was the conduct that you were complaining about? When did it happen? Where did it happen? Who were all present? Were there any witnesses? You want to document that. And if there are any documents that can prove your issue directly or indirectly, you want to keep records of that. So for instance, if workplace harassment took place in a meeting and there were minutes of that meeting that were recorded, you want to get a copy of those meetings and put them in your record, because that will at least, even if the specific comments, harassing comments, were not documented, at least it will support your allegation that you were attending so-and-so meeting and this was said. And so there is some sort of indirect evidence that will help you later down the line. So documenting what you're experiencing and going through is a very crucial, very important step that you must do. Step number 3. Review policies. Oftentimes when you're hired at a workplace, when you sign up, you sign the employment contract, you get handed over employee handbook, workplace policies. They may include anti-harassment policies, anti-violence policies, human rights policies, employee code of conduct. All of these things may be there, and you may have looked at them a few years ago and not recently. So you want to get a hold of all of these policies, review them again to make sure you understand how your employer's policies define workplace harassment, workplace bullying, what kind of conduct is covered in that, and then you want to understand what is the process if you have a complaint, because you need to follow that process in launching your complaint. So you want to review those policies just to be current. And in a situation where you work for an employer who doesn't have any of those policies, then that's a problematic issue for an employer. That sort of indicates that the employer has actually not turned its mind towards workplace anti-harassment and anti-violence issues, and so that may lead to problems for the employer in dealing with your complaint. So review policies, apprise yourself of how workplace harassment and bullying is defined and what is the process of filing your complaint. And then finally, the step number 1 is you file a complaint. Now, where do you file a complaint? What do you do with that? You generally have 3 avenues of filing complaint. Number 1, you file a complaint with the employer. Number 2, you can file a complaint with the Ministry of Labor in Ontario. And number 3, you can actually go to a lawyer, commence a court action if it's appropriate, or file a complaint an application with the Human Rights Tribunal if your matter is also covered under Human Rights Code. So all of these three avenues are open to you. My recommendation always is that the first step you want to do is file a complaint with the employer. Employer may not be aware of what's going on. Employer may not know the extent, the nature of harassment that you experience. And so you must give employer an opportunity to investigate and to remedy the situation to the extent. And so that's an important step that I always recommend that you must do. Second step, you don't need to exhaust the step number one to the employer. To go to Ministry of Labor, you can go to the Ministry of Labor directly, but my recommendation is to go to employer first. You can file a complaint with the Ministry of Labor, and Ministry of Labor, the legislation has been strengthening more and more from the time that it was initially brought in, 5, 6, 7 years ago. Ministry of Labor will either appoint its own inspector to come and investigate, or will force the employer to hire an external investigator to conduct an investigation. So either way, Ministry of Labor will take your complaint and will take certain actions, and then your matter can be investigated. And finally, like I said, you can go contact a lawyer and commence a court action if that's appropriate, or file an application with Human Rights Tribunal if that's appropriate. Okay, I want to quickly talk about investigation so you can understand the concept of investigation. When you file a complaint with the employer, generally speaking, there are two options that the employer has: either to conduct an internal investigation or conduct an external investigation. And employer will decide which one is appropriate based upon the nature of your complaint, based upon its circumstances. So internal investigation, as the name implies, is done by somebody who's internal to the employer, internal to the organization. Could be an HR person, could be a senior manager, could be a vice president, could be any of those people who may be appropriate, who are qualified, who have competence to conduct an unbiased investigation. But sometimes that internal investigation is not appropriate. So for instance, if your complaint about bullying and harassment is against the director of human resources, then anyone from human resources is not an appropriate person to conduct an investigation because of the potential conflict, because of the potential bias. So there may be circumstances based upon the nature of your complaint, based upon who you have complained against, that it is appropriate to conduct an external investigation. And if you believe that your circumstances are such that employers should conduct an external investigation, hire a third party to conduct the investigation, then you must ask for it, at least in writing. And if the employer chooses not to act upon it, that's their prerogative, but then it may cause harm to the employer for not taking care of the issues objectively. So investigation is important. A lot of senior lawyers, I do investigations for corporate clients, not my own, but other lawyers' clients, because I don't represent them. I go as an investigator to conduct workplace investigation and then provide my unbiased findings and recommendations if asked for. So what is the conclusion? My recommendation on workplace bullying and harassment is always speak up. A lot of employees that we talk to, they're always concerned about fear of losing their job or reprisal at workplace, that what if they stand up and make this complaint, what if they lose their job, and what if they will get retaliation in other forms. Reprisal is protected under Occupational Health and Safety Act, just so you know. But more importantly, what you want to understand is that if you don't speak up, if you don't stand up, if you don't file a complaint, then the workplace bullying and harassment won't stop against you, won't stop against other people, and it will get worse. And then the problem with that is not only that it gets worse, but it has huge negative impact on your life. It impacts your relationships with your family. It impacts your relationship with your friends. It causes significant damage to your mental health. So all of these things are cumulative. They're very toxic. They're very negative. So, you may end up in a situation where if you don't stand up, if you don't speak up, the party who is causing harassment and bullying will continue and create a situation where you either walk out of the job and resign, and not having taken care of your rights. So I think this lecture gives you some understanding of your basic rights, and then hopefully you will be able to handle the workplace harassment and bullying situation in your workplace better. This is a topic that is sort of growing. There will be circumstances which are very specific and examples of workplace bullying and harassment that you want us to cover. We'll be happy to continue adding on this topic. And if you have any questions, by all means, please contact us. We'll be happy to keep adding on to this topic. Thanks for watching.